Good morning. It is now 10 o'clock. Aloha and welcome to the statewide training on fair housing for 2023. Our theme this year is Fair Housing Choices for All Voices, Building an Equitable Future. And today is our second session titled Ask the Experts, moderated by the U.S. Department of Housing and Urban Development and the Legal Aid Society of Hawaii. My name is Yiyang, and I'm the Fair Housing Coordinator for the Department of Community Services. On behalf of Mayor Rick Blangiardi and the City and County of Honolulu, it is our pleasure to host Fair Housing Month for the state of Hawaii. Again, on behalf of our statewide Fair Housing Coordinators group, we thank you for taking the time to join us in this very important training. Registration for these WebEx conference series far exceeded our expectations. And again, there is more than 800 registrants, of which more than 30% are first-time attendees. We hope you enjoyed last week's session on Fair Housing 101. Today's session will feature three renowned experts in fair housing. They are Representative Troy Hashimoto from the Hawaii State House of Representatives, Ms. Yiyang Wu, a fair housing attorney with Relman Colfax, PLLC, and Ms. Jennifer Stolze with the U.S. Department of Housing and Urban Development, Honolulu FHEO office. And today's session will be moderated by Ms. Pamela Zai, also with the U.S. Department of Housing and Urban Development, Honolulu FHEO office. Welcome, panelists. I'd like to take this opportunity to go over a few important things to know before we start. First, when you signed in, you should have found a link to the most up-to-date PowerPoint presentations being shown today. I think Dylan put in a note in the chat box for those of you who weren't able to find it. There's a way to go back into how you logged in to get the two PowerPoints. Second, because of the size of this conference, all attendees' microphones and webcams have been disabled. We have collected a lot of questions from registrants on various topics. However, if during the training session you would like to ask a question to the presenters or panelists, we ask that you direct your question to the all panelists link in the chat box of the WebEx program. We have people monitoring the chat room and we'll be gathering your questions as they arrive and forwarding to the presenters and panelists. Presenters and panelists will try to get to as many questions as they can during the Q&A portions of this training, time permitting. Please take a second to find that feature now. And finally, I'd like to reintroduce the Fair Housing Coordinators group that participated in the planning and coordinating of this conference and ask them to turn their cameras on when introduced. For the County of Kauai, Jocelyn Marie and Steve Franco. For the City and County of Honolulu, myself, Yiyang, Emma Grohowski, Dylan Ramos, Brian Minatoya, Kerry Kanashiro, Allison Mikuni, Ailina Laborte, and Cheryl Belisario. For the County of Maui, we have Linda Munsell, Buddy Almeida, and Saumalu Mataafa. For the County of Hawaii, Christina Pineda and Ann Bailey. For the State of Hawaii Department of Human Services Homeless Programs Office, Harold Burkeen III and Anna Marie Piloton. For the State of Hawaii Housing Finance and Development Corporation, Christopher Woodard, Kerry Higa, and Lance Dong. For the State of Hawaii Department of Hawaiian Homelands, Cynthia Resentes. For the State of Hawaii Public Housing Authority, Joaquin Manabusan and Ryan Akamine. For the Legal Aid Society of Hawaii, Cynthia Moore, Nicholas Severson, William Tu, and Pua Marquez. For the Hawaii Civil Rights Commission, Marcus Kawatachi, Carolyn Vieira, and Heather McVeigh. For the U.S. Department of Housing and Urban Development, FHEO Office, Jelani Madaraka, Jennifer Stolze, Pamela Zai, and Shelby Collett. I would now like to reintroduce you to Christina Pineda of Hawaii Island and Pamela Zai, who will be your moderator for today's Ask the Expert session.
Good morning, Daryl. Thank you. I'm going to go ahead and pull up our slideshow for our first expert.
Thank you so much, Daryl. Hi, everyone. Aloha. My name is Pam Zai. I'm in the Office of Fair Housing and Equal Opportunity in Honolulu for the U.S. Department of Housing and Urban Development. I want to welcome you if this is your first session. April is Fair Housing Month, so happy Fair Housing Month. And thank you to our partners for putting these events on throughout the month. Stay tuned for, I think next week, our partners at Legal Aid will be putting on something about reasonable accommodations and assistance animals. So if that interests you, stay tuned. And if you're returning, I want to say thank you for all of your interest and your work in this space. This year is especially important. I'd like to recognize that it's the 55th anniversary of the Fair Housing Act, also known as one of our very important civil rights acts. We'll be hearing from several experts today. Thank you, Daryl, for the introduction. I just want to start with a very short introduction for each of the experts on our panel. I know our time is limited with some of them, so if each of the people could speak a little bit about where they're from, what their fair housing background is or interests. I'd like everyone to take 2 minutes maximum to introduce themselves. Let's start with State Rep Troy Hashimoto, please.
Hi, good morning, everyone. State Representative Troy Hashimoto. I currently chair the Housing Committee. I just became the Housing Chair, but I was serving as the Vice Chair for the last term, and I've been on the Housing Committee since 2018. So done a lot of work legislatively to promote fair housing. I represent Maui County, Wailuku specifically, and I also used to work for the Maui County Council for 8 years. So glad to be here.
Thank you. Up next, I have Jennifer Stolze from HUD.
Hello, aloha, everybody. My name is Jennifer Stolze. I work in the Office of Fair Housing and Equal Opportunity at the Department of Housing and Urban Development. I'm a lead equal opportunity specialist. And prior to working at HUD, I've been at HUD for about 3 years now. And prior to that, I was in the compliance office at Hawaii Public Housing Authority. Prior to that, I worked at the state capitol, and I was working for various committees while there, and housing was one of them, which is how I began to be interested in housing and fair housing. So thank you.
Thanks, Jennifer. And last but not least, we have Yiyang Yaya Wu, a partner at Relman Colfax.
Hi, Pam. Can you all hear me? Is that working? Great. Hi, everyone. Thank you so much for having me. As Pam said, my name is Yiyang Wu. I go by Yaya. I live in Washington, D.C., where it is 90 degrees today and humid already in April, so I wish I could be there with you. I am a partner at Relman Colfax. We are a civil rights law firm, so we bring cases on behalf of people who have been discriminated against in the context of housing, of lending, of police accountability, of public accommodations, and the whole slew of the civil rights laws. And we also have a practice of counseling housing providers and institutions who, as we say, want to do right by the fair housing and fair lending laws. Again, pleasure to be here. Thanks so much.
Thanks, Yaya. So I just want to do a very brief overview of what you can expect to hear from today. All of our experts will have different areas and we'll have a big Q&A at the end. But these are sort of the topics that are kind of the emerging issues in fair housing law. I know here specifically in Hawaii, people have a lot of interest in our, there's a newly passed Section 8 discrimination law. Rep Hashimoto will be talking about some of the other local developments in Hawaii and potential for future legislation. I have on our agenda that my colleague Jennifer Stolze will be talking about some of the new HUD developments that have been going on. The law is constantly changing. It was passed in the 60s, so there's always something new, or we expanded or interpreted things a little bit differently, and sort of what's going on with the department and on the federal level. And last but not least, we will turn to Yaya to talk in the private litigation space, and sort of what emerging issues has her firm worked on, sort of what are kind of the new spaces that they've been working on the civil rights, fair housing front. I'm going over some cases. So to start, I turn it over to you, Rep. Hashimoto.
Well, thank you once again for allowing me to be here and talking about some of the pieces of legislation that we've been working on over the last few sessions. And we've had, we've seen some really good success. I'm not sure if we can make the slides a little bigger, but I think one of the big things on how we really got into the housing space of, just the day-to-day operations of it was because of the pandemic, right? Because when the pandemic hit, the governor put in an eviction moratorium. And so it was the housing committee's task to figure out how to get us out of the eviction moratorium. And so we brought together all kinds of very interesting people from different backgrounds who had very different experts in the area. And we crafted Act 57, and that was the pathway to get us away from the eviction moratorium. It included a heavy emphasis on mediation. It included a heavy emphasis on, incorporating federal rent relief. And at the time when we were crafting legislation, we weren't even sure that we were going to get that type of federal rental relief. But luckily, the combination of the two things, we were able to have a very successful program of making sure that we, had an off-ramp from getting us away from the eviction moratorium. And we were very successful. I think we were written about nationally on how we set that up through Act 57 and how we incorporated it with rental relief. And so I think I'd like to think that we didn't have a huge fall off in evictions because of Act 57. And we're continuing monitoring it because I think we possibly are facing another cliff because at the end of this summer, we're about to end all of our federal rental relief. And so once that ends, there's another bill that we are working on to make sure that possibly we can continue a small rental relief program along with bringing back some of the mediation programs so that we can have an off-ramp once again from the federal rental relief. So we're done with the eviction moratorium. Now we're starting to wean ourselves off from federal rental relief, but I think it's a slow step. It's just the function of the pandemic. And I think it's interesting now because I'm looking at the data, and what worries me a lot is that because of inflation and because of the rental increases, the people that were just kind of making it and were, at some point benefiting from federal rental relief, they're going to now not have that safety net. And so we got to really figure out how to make sure that we don't have another crisis on our hands. And so we're hoping that we can get something out of the legislature this year. There's going to likely be no more appetite for federal relief because I think at this point they're trying to take money out of the economy instead of pumping more into the economy. So it's really going to be on the state at this point and the counties to try and figure that out. But I think it's a real issue. We're aware about it. We're trying to figure out a way to make it happen. And so I think we just know that that's one thing that we're working on. So next slide, please. So I think just based on that premise, right, we worked on Act 57. We had a really great working group. And so at that time, we were kind of figured out, okay, let's move on to the next issue. And the issue of Section 8 was kind of like lingering. And I think there was a lot of advocates who really wanted us to take a look at how do we better take care of Section 8 voucher holders. I think there was a lot of perceptions that they were being stigmatized, that they're bad renters. And I think we felt like we needed to change that. So we put another working group together to tackle Section 8. So next slide, please. We looked at legislation that did not pass in previous sessions. And we said, okay, let's sit down and let's figure out why they didn't pass and let's figure out a way to move this forward. And so we looked at, not only those bills, but we looked across the country to see how other counties and states were dealing with rental discrimination. And so we put another working group together, which is next slide, that essentially are helping people. And it was a two-part bill because essentially what we wanted to do is we felt that there was incentives that helped more than punitive type of actions. And so the two parts needed to go together, and the working group felt very strongly that you needed both because sometimes you get more out of the incentives versus penalizing people. And so we were looking at why, people weren't taking Section 8, because I think part of it, again, it goes back to the perception that they may damage property. The application process takes too long. The inspections weren't happening. So it's just more burden on a landlord for not necessarily wanting to take Section 8. And so I think we tried to address a lot of that in our working group. And I think there was a lot of things that we came up with that were really good, right? So the incentives part is making sure that we will cover any type of damages. So there is a fund that we created that will take care, that you can apply for any type of damages that happen with Section 8 units. And I think it's interesting, I think we previously had a program and nobody was really using it. But I think the important thing is the level of comfort that you're providing by having this fund. And so even though you're not expending a lot of money out of that fund, if you can put in the minds of landlords that there is this safety net that just in case you need it and it's there, hopefully that will open the door to allowing more them wanting to take Section 8. We heard loud and clear that inspectors were an issue, and so coming to your place to get your Section 8 ready. And so I think one of the things that we worked out with the Public Housing Authority is that can you do your inspections in a certain period of time? And so one of the provisions that we put in there is that they would have to do it within a very defined period of time. And we gave them money for additional inspectors to help with the inspection process. And so hopefully that will get them out of their mind of just thinking of waiting to get an answer from the housing authority. And so I think hopefully that will change. And I think one of the big things that happened in the meantime is that Hawaii has been got the designation of a move to work pilot program. And so now the Public Housing Authority can do a lot of innovative things that they tried during COVID that they can now implement. And so they get to select various things from a menu of options to help them streamline their processes. And so I think they're in the process of figuring out what they're going to select. And so some of the things that we actually put in the incentives bill, they can inherently do now because of their move to work designation. And so I think that's great. So I think between the two things, including some of the bonus monies that we put in, so if you sign up for Section 8, we also put in a provision where you'd get, I think, the first month's rent covered, because part of it was people were concerned that they're not going to get their rent check for a long time. That was another misconception. And so I think we put that in the bill, but I think that is something that a combination of all the things, we hope that is going to at least make people think twice and say, okay, maybe Section 8 isn't that bad and we want to do it. So that was the incentive side. And we believe that the incentive side was one of it. So next slide, please. So we had the incentives, and then we found that source of income also was a problem. So people were kind of saying, oh, okay, we don't want Section 8. And so they were putting that in advertisements, and we felt that was a bad perception being allowed throughout the state. And so essentially we put a ban on the source of income, right? So you can't discriminate based on your source of income. And that was the second part of the bill that we felt was important. And I think, when you inherently, it seems like a no-brainer, right? But I think the hard part is finding a balance between the people, the landlord groups, the people that represent landlords, and of course the advocates. And so it was a delicate balance in terms of trying to figure out how do we ban the source of income, being able to discriminate that. And so I think with that, and I think part of it was we had to make some concessions. And so I think there is an exemption for small landlords. And I think that is something that we just have to watch and see if it's still a pervasive problem. Because of the smaller landlords, we'll have to retake a look at the legislation, but at least we were able to pass this source of income ban. And I think that is critical, and we're going to have to wait and see, because it will start on May 1st. None of this has happened yet because we wanted to give time for the education piece, because I think part of it is when we heard loud and clear that the landlords needed to adjust to understand what they could and could not do. So we can take a look at what specifically, next slide, of what the pieces of legislation show. So HB 1752, that was the incentive program. And so that's what you can you go and look at that bill and read through it of what exactly it entails. Next slide, it also show you the SB 206, that's the prohibition, and there's also some penalties associated with that. And so I think that goes into effect May 1st, 2023. So that is something we should be watching out for, and you should know that this is a new piece of legislation that will be beginning very shortly. So I think overall in the next slide, you can see just what the goals that we were trying to accomplish with this piece of legislation. We wanted to have access, people to have more access to the units, because I think we've been told over and over again that people are given the voucher and they just can't find a place. And so that's just the whole reason why we needed to tackle this situation. I do want to caveat this whole thing and say, because the rental discrimination is statewide, but the incentive program, because the state only controls the public housing authority, we're hoping that the cities and the counties will follow suit with these incentive programs, because we cannot give additional incentives to the city and county of Honolulu, Maui, Kauai, and Big Island. So hopefully the counties will look for their own incentives to implement to allow for more Section 8 voucher incentives to be deployed to those who should be renting, because we wanted it to go statewide, but we couldn't really figure out a way. But again, I know there's some of those folks on this call, so I really challenge them to take a look at what more can the counties do. But again, as I said, the rental discrimination prohibition is statewide. So I think next slide, we also are continuing to take a look at what else we want to do. And so I think we're going to watch how this moves forward. I know there was a bill this year that wanted to actually give the counties the ability to do rental discrimination, prohibit the rental discrimination. I think we deferred that bill because this bill didn't even take effect yet. So we want to see what the implementation is going to be, what some of the concerns might be, and then of course it has to be data driven. So we're going to be watching the data, working with the city and the state and the counties to see if there's any difference, and if not, then we probably have to retake a look at what other things that we can put in place. Next slide, please. The next bill that I did want to discuss real quick is we also this year have SB 930, which is what we call the application screening bill. This is in conference committee. Essentially, what the advocates and the Department of Consumer and Commerce wanted to make sure that it was clear that you couldn't charge. Originally, how the bill started was $25 for screening fees. And so I think that we were kind of going back and forth of $25 was the number, because if you talk to some landlords and people who are property managers, they're saying 25 is too little. Some said it's too high. So essentially, I think my feeling on that issue, and again, I have to find a balance between the landlords and the advocates and all that, is I think we're probably just going to take the $25 out, and we're going to we're not going to put an amount in statute, but instead how the language is written is that you can only charge what it costs you to screen, and you have to provide proof of what the cost is of the screening. And I think the approach to this is to make sure that as costs go up, we don't have to go and amend the statute every single time. And I think part of it is there was an issue, there's a push and pull between who is screened, right? Because I think the landlords want everyone who is above the age of 18 to be screened. I think there's some who just want it to be those contributing to the monthly payments. I think there's some who really just are upset that you pay a screening fee every single time you apply to various locations, and of course you're not going to get many of those locations, and I think they're pocketing the money possibly without running some reports. And so I think that's why the receipt being able to get a receipt and showing what the costs are really important, to show that that was actually used for the intended purpose. So we'll see. This is going to be a push and pull between the House and the Senate, and the advocates and everyone in conference committee, but this is one to watch. So next slide. Yeah, so next slide. All right, so that's just more on the screening fee. So let's see if we have anything else. I think that's the last slide there. So I think those are all of the two bills that I think we wanted to highlight today. I think, as I previously said, a lot of this is data driven, so we just kind of have to watch. I think my philosophy always is you can think you know what the solution is, but until it's implemented and you can kind of see how it moves, then you can really know if your hypothesis actually came true. Because I think oftentimes what I do have seen with especially housing bills, you think one thing's going to happen and it actually doesn't turn out that way. So I think that is where we're at this point. I think the other big bill, as I mentioned at the start, is we're making sure that we can get some rental relief. That's a big one for housing. I think those who are facing evictions, we're going to be watching that as well. And I think we're always looking for ideas. I think when we're looking at the landscape, I think this is going to be a very interesting next year with the rising interest rates, rents going up. I think we're going to have to see what are the problems and the issues that are arising with fair housing. And we may have to tackle that next session. And so I think we'll be, working through the interim to find those specific projects. We'll take a look at all the bills that didn't move, because I know there's a lot of advocates who are a little disappointed in some of the bills that didn't move, but I think this year we made a concerted effort to say we're going to tackle screening fees and we're going to tackle rent relief, and those were the two main issues. And so I think we'll have to see what else is out in the universe. So we're always, if you have any ideas, I'd love to hear it. Just make sure you can just email me, Rep Hashimoto at capital.hawaii.gov. Or set up an appointment with me, and I'm happy to discuss. We'll be ending the first week in May, so we'll know where all of this stands, and then we'll be starting for the next session. So I appreciate you having me, and hopefully this kind of gave you some insight into some of the bills that we're working on.
Thank you, Representative Hashimoto. So I know there's a bunch of questions in the chat and your time is limited, but I think I want to just highlight, people are, this is a pretty complex issue. I think you made a very compelling sort of outline of, why these things were being advocated for and being implemented. Could you talk a little bit more about do you see where future legislation is going, where your goals are? Obviously we've got a lot of work to do, but I just want to see, kind of where do you think this is going to head?
Yeah, when we take a look at future pieces of legislation, I think in the short run, it's really going to be about how do we avoid this cliff, right? Of a surge of evictions, surge of the drop off in federal rental relief, drop off of federal benefits, and so I think that we're going to have a strategy on how we're moving forward, both the state and the county, on how we're going to use existing funding that we have to get it to people that are in need. I think we're really what we're looking at right now is it's just that gap group, right? Who are the people that are really just on the edge, and I think that's where we're really going to have to focus. And so I think a lot of the things that we're looking at is how do we better implement. The other part of my job is although we're looking at these specific type of programs, we're looking at long-term housing projects, right? And so I think we're trying to make sure that the housing pipeline of things being built is, robust, because if we don't have permanently affordable housing over a long period of time, that we're just going to keep having to subsidize. So what the end goal is we're trying to move away from the subsidy, just having something that's just there, right? And so I think that is the long-term goal of the legislation that we're trying to do. So a lot of what we put our time and effort into is getting those projects off the ground. So I think it's complicated. A lot of it involves infrastructure dollars. So you'll see the state will, last year we put $1 billion towards housing. And but a lot of that still needs to get digested. So we're going to be spending a lot of time in making sure that those go to the right places, and making sure that the dollar stretches. Because what I'm finding right now is when we're trying to build a low-income housing tax credit project, which is 60% area median income and below, there's cost overruns and things are kind of getting harder to pencil out because of just all the external factors of supply chain issues, rising cost of materials, and so we're having to apply additional funds to that. And so I think that's very problematic to me in the short run. And so we're trying to manage all of that, and making sure that projects that are actually right above that, which is 60 to 100%, we're trying to work on that as well to make sure that those, we're not only doing fully subsidized, but we have the kind of the gap group that's being taken care of as well. So not necessarily specific pieces of legislation, but it's within the realm of the housing pipeline that we need to really work on that as well. And we'll continue to work on that.
Thank you so much. That is very insightful and very helpful to know about that on the local level, and that there's so many things that are developing and in the pipeline and in the works. I want to turn next to my colleague over at HUD Honolulu office and fair housing, Jennifer Stolze, to go over a little bit about some of the upcoming and developing federal level issues. Jennifer?
Thank you, Pam, and thank you, Rep. Hashimoto. So this is my presentation on kind of VAWA, which is we'll go into that, and some sex discrimination and harassment, and also neighbor harassment. I'll be going through these slides pretty quickly because I don't have much time. So there's a lot of content in them. So please feel free to look more closely at them as time permits for you. Next slide, please. This is my contact information. If you have any questions, comments, concerns, feel free to call, email, go to our website. Next slide, please. So if you're new to the Office of Fair Housing and Equal Opportunity, the mission of our office is to eliminate housing discrimination, promote equal opportunity, and achieve diverse, inclusive communities by leading the nation in the enforcement, administration, development, and public understanding of federal fair housing and civil rights policies and laws. Thank you. Next slide, please. And our activities include education and outreach, technical assistance. That's for you guys. If you need any technical assistance, please feel free to reach out to us or legal aid. That's what we're here for. We investigate fair housing complaints. We conduct compliance reviews, kind of address systemic issues. We manage fair housing grants, and we ensure civil rights compliance in HUD programs. Next slide, please. So I told you I'd be talking about VAWA. That's the Violence Against Women's Act. It's really only applicable for recipients of federal funding. So for private housing, this would not be applicable, but it provides housing protections for people applying in or living in units subsidized by the federal government and who've been experienced domestic violence, dating violence, sexual assault, or stalking, and it's to help keep them safe and reduce their likelihood of experiencing homelessness. Now, there is a provision on the private side, and we will get into that. That's kind of similar to VAWA, but a little bit different. So what's new about VAWA for 2022? So there's been some changes in the law. Now HUD enforces VAWA. So retaliation is prohibited. You can't discriminate against people who exercise their VAWA rights, and you can't retaliate against people who exercise their VAWA rights. So next slide, please. So there's some similarities and differences between the Fair Housing Act and VAWA. The Fair Housing Act protects characteristics such as race, color, national origin, sex, including sexual orientation, gender identity, religion, familial status, and disability. And it prohibits discrimination based on that. And this would be largely on the basis of sex discrimination. It would be comparable to the VAWA. And VAWA is, for programs that receive federal funding. And please feel free to read this more carefully as time permits. Next slide, please. So discrimination based on sex for federal, this is interpreted to include gender identity and gender expression. Also, there was an executive order recently based on this decision in Bostock v. Clayton, which held that prohibitions against sex discrimination in the workplace contained Title VII rights and to include discrimination on the basis of sexual orientation and gender identity. So that's been codified. Next slide, please. And promulgated under a new memo for HUD. So a little bit about gender identity and sexual orientation. Both are prohibited by discrimination based on sex under the Fair Housing Act. So gender identity is one's own internal sense of self and their gender, whether that is man, woman, neither, or both. Unlike gender expression, gender identity is not outwardly visible to others. So it's not about how you dress or express yourself to the world. Sexual orientation refers to the enduring physical, romantic, and/or emotional attraction to members of the same and/or other genders, including lesbian, gay, bisexual, or straight orientations. Next slide, please. Okay, there's a whole laundry list of what is prohibited under the Fair Housing Act, and again, you can take your time to read these. I'll read kind of a few of them. Refuse to rent or sell housing, refuse to negotiate for housing, set different terms, conditions, or privileges for the sale or rental, falsely deny that housing is available, make any discriminatory advertising, impose different conditions such as sales prices or rental charges. You can't harass a person. You can't delay maintenance or repairs based on a protected class, limit privileges, facilities, etc., discourage the purchase or rental. So there's a lot of things that you're not allowed to do, as you can see from this very long list. Next slide, please. So examples of housing discrimination because of sex, which includes the actual or perceived gender identity or and sexual orientation, is and this helps to kind of ground it. I mean, you get the idea that you're not allowed to do it, but how does this really play out in real life? What does it look like? Well, it could be a realtor refusing to show houses listed for sale because the buyer is transgender. A housing provider would maybe refuse to rent a house to the same-sex couple because of their, quote, family composition, which is comprised of two individuals of the same sex rather than two individuals of the opposite sex. It could be a tenant is evicted after the housing provider discovers the tenant has dated persons of the same sex and identifies as a bisexual. Or refusing to authorize repairs because they don't agree with the lifestyle of the tenants. So there could be a lot of them. There's a whole list, so it will help you understand how this would play out in the real world. Next slide, please. So what is the evolution? I mean, it's gone through a bit of an evolution at HUD. This is kind of, you know, in 2012 there was the equal access rule, which and a series of rules to ensure that every person has equal access to HUD programs without being arbitrarily excluded, regardless of sexual orientation, gender identity, or marital status. In a 2016 harassment rule, HUD reaffirmed its legal interpretation of the Fair Housing Act's protection against sex discrimination because of gender identity. And in 2016, FHEO also instructed the regional offices that discrimination because of real or perceived gender identity is sex discrimination under the Fair Housing Act, and discrimination against persons because of sexual orientation may be sex-based discrimination when motivated by perceived nonconformity with gender stereotypes. Next slide, please. The current law, what is that? So as I said recently, as of February 11th, HUD now investigates these kind of complaints based on gender identity and sexual orientation, sex discrimination. They'll be investigating in conjunction with other things if there's been other allegations, and continue to interpret and enforce the Fair Housing Act's prohibition on sex discrimination to include that discrimination on sexual orientation and gender identity. And you can go ahead and click through to the links to the executive order. Next slide, please. I think that last week, if you were in attendance, my colleague Pam told you all about the LGBTQIA+ Fair Housing Toolkit, and I've laid it out for you here and included a link to it. So again, you can do that as time permits. Next slide, please. Okay, we're moving into sexual harassment. What is that? What does it look like? It's a form of sex discrimination. It's prohibited by the Fair Housing Act and other laws. it falls into two categories. One is quid pro quo and hostile environment sexual harassment. Quid pro quo is something where you say, I'll do this if you do that. So its examples is when a landlord tells an applicant he won't rent her apartment unless she has sex with him. A manager evicts a tenant after she refuses to do certain acts. A maintenance man refuses to make repairs unless the tenant gives nude photos of herself. A couple of examples. These things can play out in a myriad of ways. And what is a hostile environment? It happens when, basically people get harassed and feel unsafe in their housing because of some acts directed at them, such as a landlord subjects a tenant to severe or pervasive unwelcome touching, kissing, or groping. They may make lewd comments, severe or pervasive, and they're unwelcome. A maintenance man sends a tenant severe or pervasive, unwelcome, sexually suggestive texts and enters her apartment without invitation or permission. And that, again, this list is not exhaustive. So if you think that you've been subjected to anything that sounds like this, definitely speak up. Next slide, please. To help prevent and address harassment. So the top one, this bubble says the property owners and managers should. And I think that a lot of property managers and owners don't realize that they actually do have an affirmative obligation under the Fair Housing Act to intervene and not just say, police matter, I'll just stay out of it. So there are things that property managers and owners can do to avoid liability under the Fair Housing Act. You can establish and enforce anti-harassment policies to help stop inappropriate or offensive conduct early before it becomes a Fair Housing Act violation. You can provide multiple ways for tenants to safely and easily make complaints or otherwise report problems, because it is difficult for people to speak up about their situations. They may feel afraid, right? So you have to provide a safe place for people to do that. You should attend fair housing training, which you're all doing. Thank you. That includes information about preventing harassment and require any staff to do so as well. So feel free to share this presentation with your staff so everybody knows what the obligation is and how to kind of move through it and address these issues before they become major issues. Take measures to ensure that people who report harassment are protected from retaliation. This is a really big one. Because again, people are very fearful about speaking up, and they know they should, they want to, but they fear for their safety. They fear harassment and retaliation. So there needs to be a safe place and a safe way for people to report these kind of violations. Talk to tenants to find out whether harassment is occurring and to teach them about their fair housing right and how to report the harassment. And hire or designate a complaint coordinator whose primary responsibility is to investigate the reports or complaints thoroughly and take the necessary corrective actions quickly. And there's a link there for managers, owners to read about things they can do to prevent and address harassment, neighbor to neighbor harassment, or manager, tenant, that sort of thing, all kinds of harassment. Please again, read when you have time. Next slide, please. So when you have manager, owner, other tenant harassment, managers are liable, owners are liable for sexual and other harassment if the harassment is committed by any employer or agent, even if supervisors don't know about it. So, that's kind of like, knew or should have known kind of thing. So an owner is liable if the owner's property manager sexually harasses a tenant. The property manager will be liable too, vicariously liable, and or the owner or management company fails to take action within its power to stop harassment of a tenant or applicant by the employee, agent, or another tenant if they knew or should have known about it. So for example, a property management company learns that one tenant has been repeatedly harassing another tenant because of their disability, and no one at the management company acts to stop the harassment. So as you can see, this is kind of a big deal. I think that a lot of managers don't realize how how much trouble they can get in for not intervening when they think that they should not intervene. You'd be surprised how much I've heard that. Next slide, please. So what can a person do if they feel they've been sexually harassed in their housing environment? Well, they can file a complaint with HUD. They can file a complaint with the Civil Rights Commission. They should be able to complain to their managers and the owners, but we covered that in a previous slide. So when you file a complaint with HUD, you should tell them the name of the person harassing, when and where it happened, the names of any witnesses, or any other people who may have been harassed. And there's some links there to some reading and to our complaint form at HUD. Next slide, please. So what's new at HUD? We have our equity action plan, and this is like a comprehensive piece of an intentional plan under Secretary Fudge's leadership to prioritize and embed equality in all of HUD's work. You can read the equity action plan. I have a link to it on the next slide. Next slide, please. Something else, this is kind of a mouthful. So I'm not going to read this whole thing to you, but in a nutshell, HUD restores the discriminatory effects. You may have heard it as disparate impact or discriminatory impact. So basically, that's a rule that is kind of on its face, doesn't seem to discriminate against people, but when you apply it, it does have an impact on certain protected classes. So in 2013, HUD had this rule against discriminatory effects. 2020 rule complicated that because there was added some new defenses, but it never really went into effect. So at the end of the day, we're back to the 2013 rule. Not much should have changed with this because there shouldn't have been any time for them to implement the 2020 rule, which was never got implemented. But for example, and if we want to talk about discriminatory effects and how that would play out in the real world, a facially neutral rule which would affect protected classes, impact protected classes disproportionately, or discriminatory effects. So say a landlord has a policy of excluding people who have any criminal records, including arrests, will often have a discriminatory effect based on race, national origin, and disability. So it's going to impact people based on their race, their national origin, and their disability, because more people who have those protected classes will be impacted by the law. They'll have criminal records more, so it affects them more. A policy with a discriminatory effect is not always unlawful. It is unlawful if it is not necessary to achieve substantial legitimate interest. So substantial legitimate interest, such as tenant safety, or it is not the least discriminatory way of achieving that interest. So you have to kind of show that you have a legitimate non-discriminatory reason for having this rule, and make that solid, and or it's the very least discriminatory way to achieve that interest. So as another example, that the criminal background is kind of the one we use most often to explain this. But suppose that somebody asked a question last week about making a policy of supervising kids at a pool. Like what should they do about that? So and we always say, well, be very careful about just creating a situation where you're treating children differently. So here's an example how it may have a discriminatory impact on families with children, that rule. So a landlord has a policy of requiring adult supervision at the swimming pool for children under the age of 5. Okay, so this is a pretty low age, right? Pretty young. This policy may have a discriminatory effect against families with children, right? Because it does. It's singling out families with children. However, it may, and I say may, and that's italicized, it may be shown that the policy is necessary for the safety of the tenants because children have been harmed when they've been in the pool unsupervised, and they've all been under the age of 5. So that's how you settled on the age of 5. But, you know, if you look at it a different way, right, say you have the policy that children under the age of 16 has to be supervised at the pool. That would probably be familial status discrimination under these facts, because, you know, what's the real reason that you want children under 16 to be supervised? Is it really based on their safety, since it's really only kids under 5 that have been harmed? You know, you have to think about that, right? Because you probably just want to discourage kids or young teenagers all congregating at the pool without adult supervision, and you're using the needs to be supervised by parents as a pretext. So we talk about pretexts for discrimination offers, and that would kind of sound like that might be a pretext. But hey, if you've seen that, you know, all the kids that have been harmed in the pool have been under, you know, there have been a bunch of kids who've been harmed in the pool under the age of 10, say, then 10 may be reasonable. It's case by case analysis. So the last example I have is a policy or a posting at a property that informs tenants that there are going to be no assigned parking, you know, which may have a chilling effect basically on people asking for a reasonable accommodation for people with disabilities, because they would be able to have an assigned parking spot if only they asked for it in a reasonable accommodation, right? So just posting a sign like that may have a discriminatory impact against people with disabilities. And there's some links down there for you to click through and read and peruse at your when you have time again. So next slide, please. And as I said before, the Equity Action Plan is a succinct look at the department's mission-driven work to build equitable communities across America. That's our Equity Action Plan is one small piece of vigorous intentional plan to prioritize and embed equity in all of HUD's work through procurement, home ownership, homelessness, and through fair housing and civil rights resources. And you can read about the Equity Action Plan through this link. Next slide, please. And mahalo for your participation and hanging in there with me.
Thank you, Jennifer, for that presentation. I think you did a really good job of addressing, you know, sort of a lot of federal requirements are very basic, they're very baseline. You know, the state usually goes a little bit further, but it's a little bit complicated, and, you know, I really like the emphasis on the sort of case-by-case analysis, so thank you. We'll definitely have questions for you at the end. Moving along, last but not least, we've got Yaya from Relman Colfax. She's going to be talking about emerging issues. Thanks. Thank you, Yaya. I'll turn it over to you.
Thank you, Pam. And again, it's a pleasure to be here today and join in with the perspective of, you know, a lawyer who is filing these types of cases. When I was asked to speak about cutting edge cases in fair housing law, I immediately thought of harassment in housing, both because it fits the bill. It is a cutting edge issue that is, you know, continually being thought about in the courts. But also, which is maybe why it's no surprise that Jennifer covered it as well, there's a really direct relationship between this area of the law and movement on this area of the law and the very, very impressive work that HUD is doing to really think about this and push it forward and draw clear lines for folks who, you know, are really on the ground and either experiencing it or managing it, or, you know, really just want to have practical, workable ways of thinking about these issues. And so I guess what I'm going to be doing for the next 20 minutes is, you know, sort of zooming in on two of the pieces that Jennifer just spoke about, zooming in a little bit on sort of how they fit in with fair housing law in general, and then providing two case examples that are actually rooted in actual cases either I myself took or are just other cases that are out there that, you know, really provide sort of helpful context on how you think about this issue. Okay, so next slide, please. Okay, so the Fair Housing Act, that's where we often start. And that's where we start with harassment as well. So harassment causes of action could include harassment against all, let's start with federally protected classes. So that's race, color, religion, national origin, sex, familial status, disability, or perception of disability. And then, of course, you've got to look at Hawaii state law as well. And that'll add age, sexual orientation, gender identity, although some of those are sort of, built into federal considerations as well as HIV infection. And so, the point is in harassment, when we think about harassment, we often think about sexual harassment, and, oftentimes it does include, oftentimes the fact pattern does include sex harassment, but not always. And so when you think about harassment, you've really just got to think about all the various protected classes that harassment often touches. Okay, next slide, please. So there are two types of harassment, as Jennifer covered. There's quid pro quo, and there's hostile housing environment. And it's not one or the other. It's not a Venn, it's not two circles. It's often a Venn diagram in terms of fact patterns. So I'll quickly, next slide, please. I'll quickly go through the HUD reg on definition of quid pro quo, which you've already heard. So it's an unwelcome request or demand to engage in conduct where the submission to the request or demand, either explicitly or implicitly, is made a condition related to something in housing, sale, rental, availability, terms and conditions, or frankly, use and enjoyment of those terms and conditions. So quid pro quo, an unwelcome request for an exchange. Next slide, please. Hostile housing environment. Hostile housing environment is an unwelcome conduct that is sufficiently severe or pervasive as to interfere with. So before you had an unwelcome request for an exchange, here you have unwelcome conduct that is sufficiently severe or pervasive as to interfere with. And then you've got the same set of issues, anything related to housing, essentially. Availability, sale, rental, or use or enjoyment of a dwelling. All right, next slide, please. To break down a hostile housing environment claim a little bit into elements, you'd want to be looking for whether the conduct was unwelcome. You'd want to be looking into whether the conduct, the harassment, was based on a protected class. You'd want to be looking to whether the conduct was sufficiently severe or pervasive to alter the condition of housing. And then finally, you're going to want to, there are various defendants, so you want some basis to really identify the particular defendant liable for the conduct. And we'll touch on that a little bit later. All right, next slide here. Who may sue? So who are my clients? An injured person includes all who have been injured by the harassment, not just the target or the subject of the harassment. So in the very, the prototypical sex harassment case, what I mean is not just the person who was sexually harassed, but also, for example, here are some examples, children or others who reside with the person who was the subject of harassment, who may have witnessed the harassment, who may have had adverse housing conditions applied to them because of the harassment. Someone who was passed over on a waiting list due to a quid pro quo arrangement. I had that come up in one of my cases recently where somebody got bumped up on a list for a highly desired apartment, and the person who that person got bumped over could be a plaintiff in a case. And then fair housing groups, so fair housing organizations whose mission is to eradicate harassment, to eradicate discrimination, and who and we'll go through this a little bit later, who, if they've done investigations and uncovered such harassment, they themselves could be a plaintiff as well. Okay, next slide, please. And then who may be sued, the other side of the V, of course. Possible defendants include the perpetrator of the harassment, as well as the owner, the manager, the condo association, essentially the housing providers, so long as they were unreasonable in their response. We'll get into that a little bit later. Next slide, please. And here we've just got the three. If you're playing bingo of my presentation, you'll hear me refer to all three of these: the Federal Fair Housing Act, state law, as well as the HUD harassment rule that Jennifer so kindly laid out for us. All right, next slide. So I've gotten through my law piece, and now I'll use two cases to really apply the law and you know, provide a way for us to talk through practically how this actually is seen on the ground. So the first case that I'll cover is CNY Fair Housing et al. Versus Doug Waterbury. This is a case that my firm filed, that I filed in the Northern District of New York, and a case that it went through significant investigation, significant fact collection, and I'll share the resolution at the end of this presentation. Next slide, please. So we always do the who, what, when, where, and so here let's start with the who. So the defendant in this case was a landlord based in upstate New York. The town is a town called Oswego, New York. It's about 45 minutes outside of Syracuse. It's a small town, and Doug Waterbury owned a lot of the properties in the town. In fact, he owned and managed over 50 properties, 50 housing units in a place that had fairly low housing stock to begin with. We represented the Fair Housing Organization. Remember, we talked about the types of plaintiffs. So Fair Housing Organization there, which is called CNY Fair Housing, as well as 6 individual women, 6 individual plaintiffs. So in this context of it being, you know, a low housing stock, you know, town where this guy owned over 50 properties, the allegations that we pled in the complaint were that we found multiple instances of Waterbury demanding sexual favors from female tenants or female would-be tenants in exchange for lower rents and other benefits of tenancy. So again, there were 6 women, but just to go through a couple of these fact patterns. Kara, she was a tenant of Doug Waterbury's, and Doug Waterbury would not allow her to sign a lease unless she ceded to his request for sexual intercourse. She did acquiesce. He allowed her to sign the lease. She moved in. She was a single mother, so she moved in with her daughter. And over the course of her tenancy, he continued to demand sexual favors of her. He would drive up to her house and wait outside, and if she ignored him, he would stay outside and wait, and eventually would call and make up some excuse about a repair for his reason for being there. Okay, next one is Amy Jo J. Amy Jo approached Doug Waterbury for an apartment, but she never rented from him. When she visited the apartment to see if she wanted to rent from him, he told her, "You won't have to pay a security deposit if you right now give me oral sex." And then he used his words and his body to prevent her from exiting the room where they were standing. So Amy Jo never rented from him, but she continued to see him around the small town, and every time she saw him, she, you know, was terrified of and reminded of the incident and the interaction. And then finally, Sarita A. Sarita A was a tenant of Waterbury, and during her tenancy, Waterbury would show up to her house and ask for what he would always call personal favors. And he would connect these personal favors to, you know, benefits of housing, like moving into the apartment earlier or a reduction of rent month to month. And then finally, CNY Fair Housing, the local fair housing organization, they found out about Waterbury's harassment on social media, on Facebook, one of those Facebook groups, and they did a thorough investigation and uncovered evidence of his harassment, not just by the person who posted, but multiple other women as well. Next slide, please. So, okay, why do I bring up this case? So, I think the biggest point is that, well, let's start with the three individual plaintiffs. All three of the individual plaintiffs that we just discussed, their claims could move forward under the harassment law as we now know it, because sexual harassment can occur even when, and so the first is, the person harassed acquiesced, did give in to the harassment. So even if they did say yes to quid pro quo, they were still harassed, and they are still, you know, they can still be a plaintiff under the Fair Housing Act. Even when the person harassed was not a current tenant and did not have a current housing relationship with the harasser, so long as the context of which, you know, the interaction occurred was in a housing-related transaction. So as I said, remember, Amy Jo, she never became a tenant of Doug Waterbury's, but she was looking to rent from him. Even when the deal that Doug Waterbury sought would have offered better terms, sort of objectively, for the person harassed. So not just, oh, I'm going to withhold something I owe you, but rather, hey, you know, any normal person would pay $2,000. I'm offering you a chance to only pay $1,800 if you give me oral sex. Even in that situation, that is harassment under the Fair Housing Act. And then finally, even when the quid pro quo ask was never explicit, it was personal favors here, but it was so frequent as to give rise to a hostile housing environment. It occurred so much that it impacted her ability to use and enjoy her housing. And then finally, of course, CNY Fair Housing's claim could move forward even though they are an organization. They are not a person, nor did they officially represent any person who was the person harassed. Okay, next slide, please. So we filed this case against Doug Waterbury and his various LLCs on August 8th, 2017. A little less than 6 months later, the Department of Justice's Civil Rights Division, they also filed a separate companion case against Doug Waterbury, and when DOJ files a case, it's United States against Doug Waterbury, even if it's a civil case. And so both cases proceeded to discovery. Our case was a little bit earlier in the trajectory, and so you know, we uncovered and you know, went through significant you know, factual discovery, and we took depositions as well, including a deposition of Doug Waterbury. Some of the facts that we uncovered over the course of our investigation, and that CNY uncovered as well. We had cell phone records confirming the harassment, so text messages that were exchanged. In one circumstance, actually, someone had this is kind of creepy, but they had GPS turned on their phone, and it would show, you know, the routes that she would take. And sometimes Doug Waterbury would take her to certain properties that he owned that were not currently being rented, and he would take her there and demand sex there. And so you could see that she would be traveling to these homes for otherwise she would have no reason to be, and that you could see whose ownership was Doug Waterbury's. We found Craigslist posts mentioning trades for reduced rent, and we found, and DOJ found multiple other victims of Doug Waterbury's that really, you know, occurred, the incidences occurred over the span of decades. And so in 2019, after discovery, after we were in the middle of discovery, Doug Waterbury settled both of the lawsuits together for $1.3 million. And he was also barred from participating in the rental and management of residential properties moving forward. All right, next slide, please. Second case study. This is not my case. It's a case that was brought by Lambda Legal, but touches on some of the things that I had mentioned earlier, as well as Jennifer mentioned. Next slide, please. So again, going back to who, the plaintiff here was Marcia Wetzel. She was in her late 60s. She identified as a lesbian. And after her partner of 30 years died, she moved into Glen St. Andrew Living Community, which was a senior residential community in Illinois. And over the course of, and this is based again on the allegations of the complaint, over the course of the next 15 months, Ms. Wetzel was subjected to a period of harassment by other tenants on account of her sexual orientation. She was called every slur you can think of for somebody who is gay, who identifies as gay or lesbian. At some point, she was actually pushed off of her scooter by another tenant. And the harassment was it was so severe and pervasive that it essentially made her just not be able to even walk around or go around the premise. She would stay in her room, she would take her meals in her room, and she would just really try to avoid seeing anybody. Her relationship with Glen St. Andrew included, contract language that said that her tenancy could be terminated if she threatened the health and safety of other tenants, and so presumably all agreements with tenants would have that language. And Ms. Wetzel informed Glen St. Andrew of the harassment that she was facing by other tenants, but Glen St. Andrew disregarded her complaints and actually, to the contrary, contrived to evict her. All right, next slide, please. So here, going back again to the key points. Marsha Wetzel's claims could move forward even when the harassment was not sexual in nature. In other words, it was not about seeking sex, but was rather on account of her sexual orientation. The harassment was not conducted by the landlord or property manager, but rather by another tenant on the property, staying on the property, of which the landlord or property manager had control. And she actually stayed living at the property during the pendency of the lawsuit. Next slide, please. So why was Glen St. Andrews liable in this situation? The theory is direct liability. So this is, in contrast to vicarious liability, where you're liable for the acts of your agents. Here, under the direct liability theater, a housing provider is responsible for its own bad acts in failing to respond adequately to harassment caused by somebody else. So next slide here. Next slide, please. Revisiting the elements of tenant harassment sort of with a housing provider lens, four things you're going to be looking for. Whether the housing provider had the power to correct and end the harassment, whether the housing provider knew or should have known of the harassment, whether the housing provider failed to take action that it knew or should have known would be successful in ending the harassment, and finally, whether the conduct of the harasser rises to the level of quid pro quo or hostile environment. All right, I'm getting towards the end. I think I saw a question earlier in the chat box about what a housing provider can do to take, what corrective steps they can take to try to, remedy or at least make better the ongoing tenant-on-tenant harassment. And I think the point here is, certainly you can evict, but there are other things you could be doing as well. So verbal and written warnings, enforcing lease provisions to move folks or evict or otherwise discipline, issuing no trespass orders, reporting conduct to the police, establishing anti-harassment policies and complaint procedures. Jennifer touched on that earlier. And the housing provider should importantly follow up with the victim of the harassment after the corrective action is taken to ensure that it was effective. You have to keep going. It's an ongoing responsibility. And then corrective action, if the harassment is actually from an employee, is trainings, warnings, reprimands, terminations, or other sanctions. All right, next slide, please. So as I mentioned before, Lambda Legal filed the case on behalf of Marsha Wetzel in July 27th, 2016. They lost in district court. The district court dismissed the case, and they appealed to the 7th Circuit. And in August of 2018, the 7th Circuit reinstated Marsha Wetzel's claims for discrimination and retaliation. It relied on part on the HUD rule that we've been talking about, but it also just relied on the longstanding case law about under the Fair Housing Act. And on March 4th, 2019, the case is settled, although I don't know what the sum was. Next slide, please. That's all I've got for you today in terms of cases. I wanted to end with this preamble to the HUD rule. I thought it was very powerful when I read it the first time, 5 or so years ago, and I continue to find it incredibly powerful. the home is a place where one is entitled to feel safe and secure and need not flee. And when folks violate the sanctity of that home, it really has an incredibly negative impact on their lives and their livelihood. So anyway, so that's my presentation, and happy to answer questions at the appropriate time.
Thank you so much, Yaya. That's a really nice way to end the presentation. I know folks have been sitting for a while, so let's take a 10-minute break and we'll reconvene for questions with our expert panelists. Let's reconvene at 11:25. Thanks, everyone.
Okay, it's 10:25. Back to you, Pam.
It's like 10:25, 11:25.
Sorry, 11:25.
That's okay. I just want to make sure our panelists are back. I know that Representative Hashimoto had to step out for a vote. Yeah, we got Jennifer. Yaya, are you back on the line? Okay, great.
Yes.
So yeah, we've had a lot of great questions coming in. Just a reminder, folks, that if you send the questions to all the panelists or to everyone, they'll get recorded, and we'll try to address them as best as we can, and we'll have follow-ups if we aren't able to address you in this specific presentation. So one question that I have for both Jennifer and Yaya is, let's see, they're talking a lot about landlord, what are landlord responsibilities? But I know we have a lot of housing providers on this training, so thank you for joining us. Like, what obligations does a landlord have? What's their responsibility to step in when a neighbor-on-neighbor harassment is occurring? What are some examples and what are some best practices?
Jennifer, you want to go first?
Okay. Let's see. So the obligation, we'll start with that, is that, if you know or become aware of harassment between neighbors, if a tenant reports it or you just observe it, you have an obligation to do something affirmative, such as, having a talk with them, perhaps sending every tenant a copy of your anti-harassment policy, make them aware make their tenants aware that there is an anti-harassment policy. There's a number of things you can affirmatively do to step in, and I think Yaya touched upon those in her cases. And there's one of my slides gives you some resources. There's a HUD page devoted to what kind of best practices you can implement to try and stay out of trouble and to be able to help your tenants effectively. That's just some of the things that I can think of. Maybe Yaya has more to add to that.
Yeah,
Okay, sorry about that. No, I think, Jennifer, those are really great. The only other thing I can think of is sometimes, and you have to ask, you should talk to the complainant and see if there are remedies that they would want. One I have heard is just like, move me away from this person, right? If you can find another apartment for me or for that person, it would really help. And that one really, for me, always stuck out as one that is fairly obvious and one that should be considered.
That's great. Thanks for your expertise on that. I have a quick follow-up for both of you. What if my landlord has taken action against the harassment or the discrimination by my neighbor, but it's been inadequate? What if they have, do they have an obligation to evict or take corrective action against the other tenant if the original actions haven't been enough?
That's a good follow-up, and I'd be interested to hear Jennifer's thoughts as well. You have an ongoing duty to continue to try. Certainly the law and the HUD rule says one action is not enough. Saying I've done one thing, like I've called the police, is not enough. You have an ongoing duty to try. That being said, you know, sort of, if the hypothetical is you've taken, you tried a bunch of things and none of it is working, at some point it gets into a factual dispute about what is reasonable, right? So have you done enough that within reason? And so I think it's hard to answer that question without more specifics, but at least you know the guardrails are, you can't just do one thing and say that's enough, and that the standard you're really looking to meet is, you know, would someone think that what you've done is reasonable? I don't think it always means you have to evict. It really depends on the circumstances, but I would imagine you would want to consult with others to figure out if you really have in fact taken reasonable necessary steps.
Yeah, thank you. And I would just say that I have seen over the years situations such as this where, you know, they say, well, it's not enough, it hasn't stopped, you know, it still continues. I want you to evict them, or I want you to move them, right? And then you offer to move the person who's complaining, you know, and they say, no, I don't want to move. Why should I have to move, right? Move them, right? But and then it gets into kind of that back and forth. It's like, well, do you want it to stop? This is what I can do, right? It maybe doesn't rise to the level of evicting that person, right? Maybe they haven't committed such egregious acts as to be evicted, but, you know, perhaps moving the person complaining to another unit would solve that or get them to another location. So that's a really good point, Yaya, and bringing that up. Always just offering options, right, to them to be able to escape the harassment or perceived harassment. Maybe it isn't even really something that anybody else can see, but that moving would solve that problem. So, yeah.
Thank you both. Yeah, I want to defer to your expertise here. When you're litigating fair housing cases, what common issues do you see with housing providers or their representatives in their analysis of fair housing laws?
I think that's a little tough. Maybe one theme I'll touch on is this concept that, and I touched on it a little bit in my presentation, but I think sometimes housing providers miss that the Fair Housing Act covers activities not just that, you know, really like outright bar you from your housing, right? Like maybe they think of it as like, okay, what I'm not allowed to do is really just like prevent you from getting housing. I'm not allowed to stand in front of the door and say you can't have this housing because of your race, because of your gender. And the Fair Housing Act it covers far, far more than that. And so when you think about your policies, right? When you think about rules that touch on conditions of your rental or conditions, you know, even just today we talked about rules governing a pool, right? These are things that the Fair Housing Act do touch. And so you really want to, you know, make sure that, you know, you think about your responsibility as a housing provider to make sure folks are fairly and equitably able to enjoy their housing and the privileges that come with housing. So I think I've seen that theme a lot. I literally just filed a brief where this is a municipality, but the municipality said, hey, you know, we just made it harder for them to secure zoning, but we didn't outright deny we didn't deny it. And the law is very clear that that's not, you know, that's not how you should be thinking about your obligations. Is that helpful?
That's great. Jennifer, do you have anything to add? I know it's not on the litigation front from the federal level, we're kind of on a neutral arbiter on the other side. But are there common issues you see with housing providers, and especially if they have representation, what kind of issues they come up with in fair housing analysis?
I can't think of anything at the moment.
That's okay. We're covering quite a few issues here. So let's see.
I've got another one.
Go ahead.
And this I was reminded of it because of Jennifer's slide on the new impact rule. I think that's another one. When people think about harassment, they think about like animus or like somebody really intentionally being nasty towards somebody. And that's not what the fair housing rule is either, right? If you have a policy that has an impact on a protected class, you really, you can be found liable, and you will be found liable on under the Fair Housing Act. So sometimes, you know, sometimes as a litigator, I want to make sure I'm not sort of, you know, I don't want to accuse someone of doing more than they did. And I also sort of sometimes want to say, just, you know, a violation of the Fair Housing Act doesn't mean I have to prove that you're an outright racist. It just means everyone's got to be careful about the things that they do and the policies that they put in place and whether they have an impact on protected classes.
Yeah, thank you. And just same thing. I mean, I'm not really involved in litigation, you know, and on the HUD side. But yeah, your actions don't have to be intentional. So there's also that.
I've got another example coming up. What if a landlord is acting in a way that the tenant perceives inappropriate? What if you think you're being harassed by sexually harassed by your housing provider? What can you do if you think your neighbor is being sexually harassed by the housing provider? Like, say you're in a, you know, apartment complex and you're not subject to the harassment, but you're seeing it going on. You know, are there any protections for you if you report them? You know, what are bystander options, obligations, and protections?
Well, this goes back to my slide about having some you know, procedures in place. You know, make a safe place for people to complain and report the harassment. You know, make sure everybody knows about it in the process and keeping it confidential, and following up. Absolutely, there are prohibitions on retaliation. It is a standalone complaint that can be brought for being suffering any repercussions for reporting an incident or reporting your own incident. So yes, you can always make a HUD complaint, Civil Rights Commission complaint. You can speak to attorneys like Yaya, you know, if it gets that far. Yeah, do you have anything to add?
No, I think you've covered it. I think the only thing is, and I'm not even sure this was part of the question, but there's no, I would say that there's no bystand, like if I, you know, if I'm a neighbor and I saw it happen, I don't think that there's, you know, I don't think anyone could call you for being on the hook for not reporting it, I think. But if the question is, you know, what are the options that you can do, I think Jennifer listed the right ones. Especially the HUD complaint, and especially look out for a good housing lawyer to walk through your option.
Yeah, and I want to remind everyone that the Fair Housing Act also protects against retaliation. So if you are filing a fair housing complaint, or it could be argued, if you're a witness to, say, neighbor harassment, and are part of that complaint, and then you get retaliated against, like that potentially could be protected under the Fair Housing Act. Let's see, there's some good questions in the chat. What responsibility does an HOA, a homeowners association of a single family home community, have if there's neighbor to neighbor harassment? Like everyone owns their place, two neighbors don't like each other for whatever reason. What is the obligation of the homeowners association?
That's a really good question. I'll take a stab, and I don't have the full answer because I'm a lawyer, so I have to say things like it's dependent on the facts. But the way the framework is it's about, there's a prong about the relationship between the defendant or the person, you know, like the HOA here, and the person who's committing the harassment. And I don't know if control is the right word, but you've got to have some sort of relationship such that sort of you can be held, you know, to be able to have influenced this person's behavior, right? And so I think it's a lot clear. I'll just be honest. I think it's a lot clearer in a landlord-tenant relationship because you have the power to evict. In a homeowners association, I don't know what the power you have there is, but sort of the further down the gradient it goes, the less likely you have responsibility under the Fair Housing Act. I don't know if is that too far? That's how I would at least analyze the situation. It's about the relationship between the HOA and the harasser.
Yeah, that's absolutely right. And the degree of control that the HOA has depends on what is in their bylaws and CCNRs. So you would be able to see what kind of things they're allowed to do or what kind of responsibilities they have with respect to, you know, being involved in that sort of thing. Or specifically excluded. Sometimes they're specifically excluded from getting involved in neighbor-to-neighbor disputes. So you have to look through your documents is really what it comes down to.
And then we haven't talked about this too much, but in this hypothetical, if the harasser is somehow, you know, I don't know, on the board of the HOA, I don't know if there's some sort of, you know, connection between the harasser and the HOA itself, then you've got a different story too, right? And so, again, a bunch of different things to consider.
Oh yeah, you bring up something very important. Like we'll see a lot in cases with us, like, you know, the HOA is unevenly enforcing their bylaws, or, you know, they only take complaints from the harasser, but not from the person who's being harassed or, you know, accusing the other person of harassment. So it's very fact specific, but just want to emphasize, just because there's a policy or there is no policy doesn't mean that harassment isn't happening and that the HOA can escape liability. I got another question. This is pretty relevant to this from the chat. What if a person that's accused of harassment argues that they're innocent? Is the landlord also responsible for finding out who's telling the truth between the two parties? You know, how do you find the truth out of two editorials, right? Like, how does that work?
Well, I think this partially goes to my comment before that it's perceived harassment, right? But, you know, if the point of view of the person who's complaining feels that it's harassment and you have an opportunity to remove them from that situation, perhaps that might be the way of solving it rather than trying to be the judge and jury in the situation, and just try and end the situation that way. I think it's hard to figure out unless you have witnesses and, you know, other such independent evidence of, you know, who's telling the truth and who's lying. But there's ways of kind of handling it where you can kind of just give deference to the person who feels a certain way and kind of move on from there. Anything else?
I agree.
I have another question specifically about the VAWA, the Violence Against Women Act. Is an immigrant who is authorized to work in the U.S. Under VAWA eligible for federal housing?
Is the question whether somebody living in a federally funded program has rights under VAWA even if they're not documented?
If they're authorized to work here in the U.S. legally.
Authorized to work here in the
but they're
US
not
legal,
a
and
US citizen.
they're living in federally subsidized housing.
They're not allowed, and they're not a U.S. citizen, basically.
So VAWA still covers them if they're living in federally subsidized housing. So yes. So that you would talk to your housing provider, ask for their VAWA process, and use whatever documentation system or self-verification system that they have to report your VAWA concern. There's different housing providers handle a little bit differently, although there is some requirements across programs. But yes, you'd be able to make a a VAWA complaint so long as you're living in covered housing program.
We've had a couple questions in the chat about sort of misunderstandings or unintentional harassment, perceptions of harassment based on cultural differences or jokes. What is your perspective on how the Fair Housing Act would treat those instances?
I would just say that when you make a joke or something where somebody feels offended by it, it's really from the point of view of the person who feels offended. So, that if you become aware that they're being offended by your jokes, don't make those jokes. It may not seem like much to you, but if you become aware of it and you know that somebody has felt like it's offensive, or even if somebody else overhears it and feels offended, you're going to have an issue. So be careful about what jokes you make, I would say. I think everybody knows that, even said jokingly, sometimes there's a little bit of truth in there. So be careful about your jokes, I would say.
Yeah, and I would echo, so it's not exactly on point, but one of the case scenarios I described, she was in a same-sex relationship, and he kept asking her about the same-sex relationship, right? He just kept sort of asking questions about, how it was, and, would they have threesomes and whatever. And, I think from her perspective, the way she told it to me is the first time it was like, okay, this person's a little bit weird, but then it got to the point where she said, okay, I think he's only doing this because of my sexual orientation, right? And so I would just say, like, again, going back to that last comment, that the sanctity of the home is so different. And so when somebody has power over you and power over where you live, and then they're making a joke and you don't know how you can react, and if you can't really freely say, I don't like your jokes, why put someone in that position?
All right, here's another one. If there's a complaint of harassing from a tenant that is happening off property, what are the landlord's responsibilities? Are they still responsible to act on it?
I think that this one has really a very key fact we're missing is who is the harasser. I have a case, my firm has a case right now where the harasser was the property maintenance person, right? So the person who had authority to sort of approve repairs or not approve repairs. And the harassment, the sexual acts were occurring off of the property. They were occurring in a motel, let's say, for example. Absolutely, that's covered under the Fair Housing Act, right? Because it's a quid pro quo request that has to do with housing, so it doesn't matter where it's happening. If the harasser is, I don't know, somebody who's not a neighbor, or, I don't know. It really depends on who the harasser is, but absolutely, I can think of circumstances where it does not have to be taking place on the premise.
Yeah, and I'll just add to that, like under VAWA, the protections against dating violence, stalking, etc. This can be covered under VAWA if you're living a covered program that received federal money. So yeah, absolutely, it could be somebody that is off the property, dating violence, stalking, such things. So, but that's only for federal funded property. They didn't really talk about it that much because I think most of our audience are not receiving federal funding, but if you are, yeah.
For both of you, how do you handle situations where accommodating a tenant's fair housing rights might interfere with another tenant's fair housing rights? I think an example we had earlier might be, if like one tenant is accusing another of harassing and offering them to move, and they're like, no, why don't you move? Another example I just got was, what if you were allowed to have one tenant to have an assistance animal, but the tenant next door is extremely allergic? how would you handle that sort of situation?
Well, I mean, I would think that, just having a discussion with the tenants on how they propose that solutions to these problems, like perhaps, for the person living next to the assistance animal, maybe you could move the person that's allergic, to a unit farther away or in a different property that's under their control. That might solve it. I mean, just have a discussion on how do you want to resolve this, right? And perhaps there's something that you can do that it doesn't have to get too far out of hand.
Yeah, in that scenario where you're talking about reasonable accommodation, and the key language there is to engage in an interactive process, right? And so it's actually really hard to think of a situation in which, truly two needs for accommodations truly cannot be accommodated. And Jennifer's example is a classic one where it could easily be dealt with in a way that you are not pitting two sort of requests for accommodation against each other.
For both of you, what can a housing provider do if they're unsure about what to do, or they worry about that they're potentially committing housing discrimination? Say they want to roll out a new policy on something, or they've been accused of housing discrimination, but they don't know where it came from or what they did. Can you elaborate? Where should housing providers go for technical assistance?
Okay, so hi, that's us. That's HUD. You can always reach out to HUD for technical assistance. So you have our contact information on various presentations that will be happening during Fair Housing Month. You can make HUD you can talk to LASH Legal Aid Society. They have a grant specifically to administer technical assistance to the public. They're not going to give you legal advice, but they will offer technical assistance the same as we would. So yeah, I mean, we're free, so why not, right?
And I actually am not, in terms of fair housing groups, they're a really great resource too. I'm not sure the availability of those resources in Hawaii per se, but certainly direct services providers and fair housing groups are a really great resource as well.
Yeah, shout out to our friends at Legal Aid Society of Hawaii and the Hawaii Civil Rights Commission, who are also on this call for all of their support and all the good work they do. So you can always go to either of those entities as well if you have questions. They may or may not be able to provide you legal advice, but they can provide you with more resources and best practices concerning fair housing. Let's see. Another question in the chat about if the property only has, say, 32 federal funded units, and there are 100 more that are not, the ones that aren't funded, are they exempt from VAWA protections?
Well, using the word exempt is a bit weird, but yeah, only the 32 federal funded tenants would be entitled to the VAWA protections afforded them under VAWA. So yeah, I guess you could say that. It wouldn't cover the entire property if the entire property does not receive federal funding.
But the Fair Housing Act applies to the other 100.
But the Fair Housing Act still applies, and you have sex discrimination based on sex, which I spent the vast majority of my slides talking about, because I think more people are protected by the Fair Housing Act than by VAWA. But since that question was VAWA specific, yeah, so VAWA affords tenants certain protections, such as emergency transfer requests and that sort of thing that, may or may not be deployed during a complaint based on discrimination based on sex. But as we were saying, that could be one way of solving that kind of case. So, you know, there's like the VAWA kind of has that built in, and then the Fair Housing Act discrimination based on sex is you're going to consider these things on a case-by-case basis, and your options to remedy the discrimination based on sex or whatever protected class there is to stay out of Fair Housing Act hot water, so to speak.
That leads right into, we have a question about federal financial assistance. If a landlord is private, but they have a Section 8 tenant using a housing choice voucher, you know, what's the difference? Are they considered a property receiving federal financial assistance versus a landlord that doesn't have a tenant with a Section 8 voucher?
Yeah, that's a good question. So technically, the landlord that's renting to a person with a voucher is not subjected to, you know, these provisions of federal funding. It would be the housing provider. So, you know, say you have a HAP contract with somebody and, you know, they claim VAWA through the housing authority, and they want to maybe end their lease early because they're, you know, exercising their rights under VAWA and they want to transfer to another location. As a landlord, you could, you know, comply with that by allowing them to terminate their lease early and move their units. But yeah, so kind of indirectly, yes, but not sort of directly, if that makes sense.
All right, we're getting really the weeds here. Oh, sorry, Yaya, do you have something to add? All right, if not, yeah, we're getting lots of questions, but I want to be mindful and respectful of everyone's time. So to wrap up, thank you both for sharing your expertise in the Q&A section. We only have a couple minutes left, so if you want to provide a few closing remarks to the audience, Jennifer, you want to go?
Okay, well, I appreciate everybody's time and participation and all the great questions that I see in the chat. And if we didn't get to your question, I believe that it will be responded to and put in a spreadsheet and posted. So keep an eye out for all those questions that you may have asked over these sessions in the next couple of weeks to see how they're responded to. We'll do our best to respond to all of them. Thank you all for attending, and yeah, I'll see you next time.
All right, I'll leave it to you, Yaya, to close us out.
Just thank you again for having me. It's really quite an honor to be with Pam and Jennifer, and thank you for Nick for having us. And if I can be of any help to anybody all the way here in Washington, humid Washington, D.C., do not hesitate to let me know.
All right, thank you everyone for joining us today. I'll give you a couple minutes back. Don't forget that we've got more panels coming up later this month. Next Thursdays is on disability and reasonable accommodation, as well as assistance animals. Daryl, do you have anything else you need to add? Or
I was just going to say that, Pam, that's one of our more frequented sessions. We have a lot of questions, a lot of people just trying to work their way through the issues. So it'll be a good session next week.
All right, thank you, everyone.
Okay, thank you.